Stratton.
Yes, ma'am.
And this is 19-33601. Mr. Stratton is charged with capital murder. And what's the announcement?
Judge, we have gotten, I think, all of the media, but we're having a wrinkle with one of the police reports that's rather lengthy that Ms. Molfino is trying to figure out why it's not transferring over from the old program.
Okay. Other than that, though, everything has been.
Other than that, I'm missing about 20 or 30 pages of police report. Other than that, I think we're good.
And what we're doing, Judge, is somewhat equivalent to kind of a reverse manual bait stamp, if that makes any sense. With it converting from workflow to Odyssey, there was all kind of glitches, including the media. We have recreated that from originals at the police department, but maybe that some of it is merged into one another, but myself and intern are going through it this time and just documenting every single page number so I can get that to Mr. Rappert and he can tell me which 20 he's missing, because just I'm missing 20 out of the 2 red wells I had. It was difficult, and I wanted to, of course, have everything, but I think we've probably exhausted all of our discussions regarding the judge and are headed to the trial docket.
So is there any reason to believe that those pages out of that police report would change the position?
I don't know, but I doubt it, but I don't know.
So here's what I want to do. I'm going to give one more reset for an announcement.
Okay.
If the case is going to trial, I want to try it before the end of the year. So we're getting already halfway through the year. So we need to start looking at some dates and what's available, if possible, before the end of
I'd
the
like
year.
to get a special setting, Judge. I have some out-of-state witnesses that.
Yeah, no, it's going to definitely be, I think because it's the nature of it and we'll definitely make sure that when it's set, it will be the case to go. We'll do a protection order if you need it and things like that. So we'll make sure everybody's available. If you have any other cases that are set that are going, that are specially set, kind of maybe start an email with me, you guys, and we can start coming up with a date. Obviously, if something happens before then and it's taken care of, that's one thing. But if we want to start looking for a date, let's go ahead and start looking for that now.
I guess we can, after we get the next reset, we can have a pretrial conference in chambers and get some dates.
Yeah, I mean, just start an email.
Okay.
And we'll start it that way. And
Because I have so many family members, I will reach out to them now and kind of take a look. If obviously with the age of it and the witnesses, et cetera, it's a lot of moving parts.
it is a lot. So that's
why.
why we need to get it set so that everybody can get everybody here and subpoenaed, and we don't, we can't. It's going to be difficult for everybody to be completely available, but if they know ahead of time and they're under subpoena, then I won't have a choice. So I'd rather do it that way.
I do have a trip planned out of the country for Thanksgiving.
You'll just make sure you have that
I'll send that to him.
vacation letter
I
in.
will off of it.
Okay. All right. So let's just do 30 days. That way you guys can please get the police report. If that changes anything, we'll know then. Otherwise, between now and then, let's start looking at other dates, but we'll have one more announcement
Yes, ma'am.
before trial.
May I be
Okay.
excused?
Yes. Mr. Parker, you have Darius Rigsby. Morning.
Morning.
This is an aggressive.
Well, it wasn't meant to be. I did that to Judge Davis one time. I went back and clapped my folder. He was back there and I didn't know it, and it bounced. He thought this was a heart attack.
Good morning. Are you Darius Rigsby?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
You know, Your Honor.
Mr. Rigsby, in cause number 25 DCCR 1089, you're charged with a state jail felony offense of unauthorized use of a vehicle from May 18th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Rigsby is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle, sentence you in accordance with your agreement to a term of 12 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with me. All right, good luck to you, sir. Can you go back with the bailiff? Andrew Howard.
Andrew Howard.
You know, one dismiss the other. Bill.
Good morning. Are you Andrew Howard?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Oh, you're on.
Mr. Howard, in clause number 25, DCCR 0742, you're charged with a state jail felony offense of fraudulent use or possession of identifying information from April 18th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Howard's not competent?
No, you're on.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will sign a dismissal as part of this agreement in clause number 25, DCCR 0741, and this will also run concurrently with your federal case. Now, as long as,
They've already been sentenced over there, and I think we're good with that.
okay, I just
I've
want to make
explained
sure.
to him that.
Well, I'm going to make sure I explain it too. The federal system does whatever they want. So I'm going to say that this runs concurrently with their case, but that's completely up to them. Okay, so it sounds like it's going to be no problem, but if it's for some reason the federal system says it's not going to run concurrently and you have to do one before the other, there is absolutely nothing I can do about that other than what I say today and what the intention is. Okay,
Yes, ma'am.
so that case is 1:25 CR 56, and as far as I'm concerned, it will run at the same time. Okay, I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir.
Thank you, ma'am. Mr. Moses, the rest of one too.
I have no idea about this. Tommy, this is Michigan.
I'm okay.
Well, I mean, I'm not representing. Usually I live there.
Sorry, whenever I get to.
Oh.
Yeah.
I'll get with him, just meet the prosecutor
Okay.
right now, email him and tell him,
Okay.
part of our agreement was to dismiss
Okay.
any misdemeanors that came out of this transaction.
So everything's safe there.
Yeah, that'd be.
All right, thank you, sir.
Like, Tommy was a federal prosecutor on
Oh, was he?
that case.
Oh, how funny.
They told the guy, said, He goes, who's my prosecutor? I said, Tommy called me, he goes, here's my pepper. I said, what?
He does those every now and then. All right, Jason Jones, it's a sentencing.
No.
You know, it's one of those ones.
Sentencing on Jason Jones.
Oh, okay, hold on. What's the name on that one? Alan? They're the same, but. You wouldn't know that if you didn't write about what you.
All right, you're Jason Jones. Okay, so Mr. Jones has two cases. We've got cause number 26 DCR 0340, which is a new offense, possession of a controlled substance, a second degree felony. And then we've got a motion to revoke, which is in cause number 23 DCCR 0390. And the underlying offense in that case is unlawful possession of a firearm by a felon. Looks like we were here. Initially, there were pleas of not true, and then in May, we came back on the motion to revoke. He changed his pleas to true to counts 1 and 2. We set a hearing today. The agreement is for a cap of 8 years in each of these cases. Is that correct?
Correct, yes.
Yes, Your Honor.
Okay, and he already pled guilty on the other one as well.
Yes, correct.
Got it. Okay, I have the original pre-sentence report from that unlawful possession of a firearm case, but I also have an updated report that was prepared. And have you all had an opportunity to review that update?
We have you.
Yes, Your Honor.
Any additions or corrections?
No, no, we're touching.
Not mistaken.
I also have just looks like 3 pages of few incident reports. If you all had an opportunity to review those as well.
Yes, I have.
All right, Mr. Parker, you may proceed.
Your Honor, we're asking that the court keep him on probation. He wants the opportunity to prove he can complete it. We're asking that you let him serve the ISF track cognitive to make him help better decisions. And also putting in the HCI program where he's tested regularly. And I mean, then it's, you know, we know whether he's using drugs, but drugs has apparently been the problem on his underlying case. I think he wants to address the court, Judge.
Give me just a second, and then I'll let you do that. I'm printing a PC. Go ahead, Mr. Jones.
Yes, Your Honor. I've had time to reflect on what brought me here before you today. I take full responsibility. And if given a second chance to complete my probation, I just need a chance to prove to you, my family, my children, I can be not a liability to my community, but an asset. I had things going on before I got locked away and started a business, and I'm a single parent. Getting my license and my diploma like you asked me to do. So
Okay.
just asking for another chance to get that done.
In just a second to review this, and then I'll let you go, Mr. Nichols. Mr. Nichols?
Judge, when we entered the pleas of true, it was right before we were about to have a hearing to prove up the new allegation. I'll summarize for the court what that would have shown. Back in June of last year, only about 3 weeks after he started probation, he was detained in an empty lot about a block off of Calder, downtown Beaumont, not coincidentally about a block also or two away from Henry's place. And what he had been doing was selling crack cocaine. He was one of several individuals in an empty lot that had an active trespass warning on it. And Beaumont police would have testified the reason they went to that lot and detained people that day was because they had received or been informed by several people that had been stopped that week with crack cocaine that they bought it from him. And so when he stopped, he's sitting in a lawn chair in this empty lot where he's not supposed to be, with a plastic grocery bag underneath the chair. And in that chair is about 11 grams of crack cocaine along with synthetic marijuana and I believe actual marijuana. And so he had gotten probation for the charge of unlawful possession of a firearm by a felon. His original felony case was a state jail from Harris County. And then almost as soon as he's put on probation for that, he's in the street selling crack. I don't see how we would keep him on probation. I think 8 years is appropriate. On both these cases, Judge, it's a second degree amount. So the new case that he pled guilty to.
So here's the issue that I have, Mr. Jones. Mr. Parker's argument that there's a drug issue. It's not a drug use issue. It's a drug dealing issue, which is what the underlying case had to do with as well. When you were pulled over for that and you got the case of the unlawful possession of a firearm by a felon, you were found in possession of the Glock 9mm with a chambered round, green marijuana in the center console, another bag in the cup holder, and then another 4 bags and a scale and a second firearm in the car, again chambered with rounds in it. Another magazine under the driver's seat and another magazine in the center console. Now here we are, you get probation for that, and 3 weeks later, you're dealing drugs again. So it's not a matter of I want to do better. It's you literally got probation and 3 weeks later pretty much just thumbed your nose at me and said, I can do what I want and I'm going to go do what I want and sell drugs where I'm not supposed to be. So at this time, I'm going to find and cause number, let's see, what do we have? Hold on. 26 DCCR 0340, find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of possession of a controlled substance. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 23 DCCR 0390, going to find that you entered your pleas of true to count 1 and 2 freely and voluntarily. Find those counts true. At this time, find sufficient evidence to find you guilty of unlawful possession of a firearm by a felon. Find you guilty of that. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certification in each of those cases that shows that the
In the end, one case moved toward trial, while others ended with guilty pleas, prison sentences, and serious legal consequences. But the biggest shock came when a defendant asked for another chance only to hear the judge explain why probation was no longer an option. So, the question remains, when someone is given a second chance, how much responsibility do they have to prove they deserve a third? If this courtroom drama kept you watching, hit like, subscribe for more unforgettable legal moments, and join us for the next case.